Court of Appeal, Division 1, is now in session.
Good morning, please be seated. We are here for oral argument in cause number CR190083, State v. Valentin. These proceedings are being audio and video recorded as well as live streamed, so we ask you to please identify yourself and your client at the beginning of your presentation. Presiding Judge Paul McMurray will be viewing these proceedings via live stream so that we can be mindful and adhere to socially distancing. Each side will have 20 minutes to present their argument. Counsel is responsible for watching the clock to preserve a portion of that time for rebuttal. Also, we have read the briefs. We have conferenced this case. We are familiar with the underlying facts. Please take that into account during this presentation. At this point, counsel, are you ready?
Yes, Your Honor.
Please proceed.
Judge, and sorry, I just wanted to stop my timer here. Okay. Judge, my name is Tom Dean. I'm actually NAP counsel in this case. Mr. Valentin, who's present in the courtroom here, he was the defendant in this case. He's the appellant. He's represented by the Maricopa County Public Defender's Office.
I know this is all, but since you're going to be arguing from down there, please argue from the seated position.
Okay.
It's your a new procedure. We don't have a microphone, so make
I'll
sure you
be
speak up.
okay. Very good. Okay, so yes, and this is my client who's present in the courtroom. Judge, we filed this appeal from a conviction involving possession of equipment and chemicals for the manufacture of a narcotic drug. In this case, it was cannabis, the extracted form of marijuana. Our argument was that activity, manufacturing cannabis and possession of equipment and chemicals to manufacture cannabis, is lawful for a patient, a cardholder, a patient or a caregiver because of the Jones decision by the Supreme Court. The state concedes that most clearly on page 21 of its answering brief, but says that we need a limited remand in order to make factual findings that are required before Mr. Valentin is entitled to immunity. However, these findings were all adequately made. It was fully litigated, these issues. The state formulated to say that first, before he's entitled to immunity, Mr. Valentin must demonstrate that he had no more than his allowable amount of usable marijuana. And to figure that out, you take the dried marijuana flower and you figure out how much dried marijuana flower was necessary to produce the cannabis, and then you combine that weight, and if it's within the allowable amount, then he's within his immunity. The problem in this case is that Mr. Valentin was found to be in possession of no amount of cannabis.
Let's start over. Let's assume at the beginning that Fields 2 is already condemned. How would, no, yes, Joe, sorry.
Yeah.
Jones and Fields.
Yeah.
All right.
Yeah.
Thanks. Has already condemned. How would a court determine if immunity applies? What procedure should be engaged in?
Well, that was the subject of some debate at the trial court level. The court in this case opted to provide some limited instruction to the jury about the Medical Marijuana Act, but then to reserve judgment about immunity. Should they have found Mr. Valentin guilty of anything, then the judge would then decide whether he was entitled to immunity for whatever he was found guilty of, based on some verdict forms that the court had drafted that was meant to kind of pigeonhole the jury's findings so that he could figure that out. Now, of course, we only get to the question of immunity if the jury finds the defendant guilty of possession in the first place, which is what didn't happen here. So the burden doesn't shift to the defendant. Yeah.
So let's talk about the shifting burden. When we talk about immunity, we are immune from prosecution, we are not being prosecuted, all of these things. If the court has to wait until the end after a verdict is returned to make that determination, do you think that's what that happens?
Well, in this case, I was urging the court to allow the jury to make that determination. I was urging the court to allow the jury to receive instruction on immunity, on the Medical Marijuana Act, and to be able to decide for themselves whether they thought Mr. Valentin fell within the immunity provisions.
What type of, sorry to interrupt, but you do you ask for a different instruction using a different burden of proof if the different burden of by preponderance if the amount to establish immunity?
Yeah. So once the state obviously always has the obligation to prove possession beyond a reasonable doubt as the threshold, the defendant doesn't have any obligation to demonstrate that he was within his allowable amount, obviously, unless the state proves he was in possession of some amount.
But let me ask you that just to
Yeah.
kind of get where
Okay.
I'm curious. Let's say the jury has come back and said possessing one ounce. What's the procedure at that point?
In this case, the way the judge did it, they had the verdict form. It required them, if they found him guilty of possession, they then had to check a box that said how much.
The amount. And that's my question to you is let's say they had come back and said guilty, and the amount is 1 gram. 1 ounce.
Well, the way the verdict forms in this case, they would have said less than 2.5 ounces.
Less than 2.
Yeah.
Okay, so at that point, if they come in, let's say they put, let's say we have a verdict form that says, tell us the amount that you
Okay.
and the jury says 1 ounce. Is there a procedure? Does the state then ask to have the jury make a determination by a preponderance? Or do you think there's more than 5 ounces by a preponderance?
Well, I think in that case, if they said we think that the defendant was in possession of 1 ounce of dried flower, usable marijuana, which is defined as dried flower, then they would effectively be saying that he's within his allowable amount.
Would the state be able to come in and say, but we think there was really more because he's not entitled to anything if community doesn't apply, so we want to find him by preponderance. Has that ever been done, you're aware, or is there some mechanism to do that?
I think that I don't think it almost is sort of a bifurcated is what you're talking about, where is there the jury make a finding and then we have a second proceeding where the defendant says, okay, now I'm going to show you that by preponderance that I was within my allowable amount. Is that kind of what you're?
Well, I think the state and the defendant already has the verdict that says there was 1 ounce. So is there a mechanism for the state to come in and say, well, we want the jury to make that, or even we'll say, so the defendant wants to say, well, I have a medical marijuana card, so I want a finding that this is less than the threshold amount.
I see what you mean. I mean, you have to have an instruction on preponderance probably, and somehow the verdict form, I think, the instructions obviously, and then the verdict form would have to say, we the jury find by a preponderance of the evidence that the defendant possessed this much, perhaps. It would be that's one way of doing it. I got to tell you, Judge, I teach this in seminars to other attorneys, and it really is, there's different ways that you could look at going about doing this.
What do you think is the way to do it? Let's say this case is charged today. They think that your client possessed over the threshold amount of marijuana. It's charged today. You want to talk about it. He hasn't done it for marijuana. How do you proceed with that? Here's the problem. We've got the jury determining beyond a reasonable doubt, and in this case, no possession of any marijuana or cannabis. But let's say the jury comes back and says, your client possessed 1 ounce beyond a reasonable doubt. Then we give another bite at the apple for the state to say immunity doesn't apply, and then we can deal with this criminal charge separately. That's what I'm struggling with.
Okay. Yeah, I mean, that obviously didn't happen in this case, but if that did happen in a case where the jury came back, the state would say, well, they'd say, what the jury's saying is that the state only proved by beyond a reasonable doubt that the defendant possessed 1 ounce. That's a slightly different standard, though, than saying has the defendant proven by preponderance that he only possessed that 1 ounce. So I think is what you're getting at. Am I right? That the duly back?
It seems like a confusing mess for jurors to make determinations by different burdens of proof.
Yeah.
It seems counterproductive to have a court come in and make a determination about immunity after a verdict when the AMA is supposed to provide protection to people that marijuana, etc. So it doesn't seem like the purpose of the AMMA is being met when we decide immunity on the back end, does it?
I agree that, like I said, I wanted more complete instructions to be given directly to the jury for them to make those findings themselves as part of the verdict rather than to have them make sort of factual conclusions that the judge then would take and decide whether that fit within immunity. I think personally that the better route is to allow the jury to make those decisions, just like they apply the law to the facts in the criminal case in chief.
Would you propose then to say that you make this finding, you found 1 ounce beyond reasonable doubt, you now want you to make the finding that the defendant is arguing immunity, and he has to prove immunity of less than whatever the amount is, we need to make that finding by Congress? Have you seen that?
I have not seen that, but I do like that. I think the way I would look at it is that the jury first is asked to find whether or not he's guilty of possessing beyond a reasonable doubt, and then second question, by preponderance of the evidence, how much marijuana did he possess, or did he possess more than 2.5 ounces? However you want to do that, whether you want to make a specific finding of weight or just whether it's over that threshold or not. So I think you could do it that way. You first have to decide.
Isn't that what they're proposing in this case? They're saying you've got that finding, the court made a mistake based on Jones, so we just want to send it back and let him argue to the jury that it's his burden to show that he's has immunity, and he can do that by establishing by preponderance.
I would agree if the jury found him guilty, that the state did meet its burden of proof and found him guilty of possessing some amount of cannabis or marijuana, that the burden would be on the defendant to then show that it was within his allowable amount. But in this case, that's not what happened. The jury found him not guilty of possessing any cannabis.
But they found him guilty of paraphernalia.
Guilty of possessing equipment and chemicals, but that doesn't have to have anything to do with. I mean, they found him not guilty of possession of cannabis, not guilty of possession for sale of cannabis, not guilty of manufacturing cannabis, but guilty of possessing equipment and chemicals that could be used to.
But are you saying the state couldn't have come in even, we're still at trial and they just want a jury instruction, could they have asked at the time, even if you find that he did not possess any of these chemicals, these drugs beyond a reasonable doubt, if you find that he has the equipment, you need to find by a preponderance whether he's established immunity?
I don't think so. I think that it's always that otherwise we're having defendants come in just based on an indictment and having to prove their innocence. Always the state must first, before that burden shifts, before it's triggered and the defendant has any obligation to prove anything, the state must first prove its case of possession beyond a reasonable doubt. Only then does that occur. And in this case, they were unable. What they want to do is go back and try to prove that he was in possession of more than his allowable amount of cannabis. Well, the jury, they already failed to do that.
But if we go back to my hypo of he was convicted of possession of 1 ounce and then he's also convicted, under that scenario, you think it would have been okay for the state to come in and say, we want to question the jurors, we want them to determine by preponderance whether he has established immunity?
I think that if the jury found him guilty of possessing any amount of marijuana beyond a reasonable doubt, then I think that yes, that the defendant at that point has the burden to prove by a preponderance of the evidence that it was not beyond his allowable amount.
Less than an ounce or an ounce. So you have an ounce of marijuana, you're indicted on possession of marijuana. You don't determine anything about your immunity and then how do we do it in a bifurcated proceeding where there's guilt and then a little preponderance so that we don't confuse jurors? I don't understand how this is supposed to work in an actual courtroom.
Yeah.
It doesn't make sense to me.
Yeah. I agree that the immunity law in Arizona is not very well developed, and I think that it's very clumsy, I think, and there really need to be some specific standards set forth that, because I mean, courts are all over the place on this. Sometimes judges just make their own decision before trial and say, I don't think that I think judge thinks before trial even starts you were over your allowable amount, therefore you don't even get to raise the defense. And so that it never even reaches the jury's ears that the person is even a card holder.
Well, I agree with my first question.
I think that the procedure should be that the jury receives instructions on immunity, and they're asked to find whether or not the defendant is guilty beyond a reasonable doubt of possessing marijuana. And then if you found him guilty of possession of marijuana, whether the defendant has demonstrated by preponderance of the evidence that he was within his allowable amount. That's how I think the jury should be the one to make those determinations.
So
I
you're
do.
okay with the state charge possession of an ounce of marijuana, agreeing to have a medical marijuana card, and
Sorry, Judge, my alarm's going up for the.
okay.
Sorry, I'm not sure I stopped it. Okay, got it.
Good,
Sorry.
Sure. I don't want to answer for you, but it seems to me it wouldn't preclude a pretrial determination by a judge. Doesn't mean that he's not still entitled to have a jury determination. Is that be your position? If the judge makes a determination ahead of time, I'm assuming you don't object to a judge ahead of time saying this doesn't meet the threshold.
In theory, I don't object to that. I think oftentimes, though, there are mistakes.
Or I'm saying if the judge says this person obviously qualifies, so he gets to present that to the jury. I'm trying to.
Well, just what always happens at the trial court level, Judge, is that when a defendant is intending on presenting the defense under the Medical Marijuana Act, the card holder, and the state feels like somehow he violated the Medical Marijuana Act and isn't entitled to that immunity, they file a motion in limine, almost without exception, to asking the court to preclude them, like as happened in this case, to preclude the defense from being able to even raise that or even disclose that the defendant was a card holder. And a lot of times the judges will grant those motions and the defense will be lost. Other times, like as in this case, the judge will decline to grant the order and it will move forward. And it is difficult because the jury in this case got limited instructions about the Medical Marijuana Act. They were obviously aware of it. They got a stipulation about how much my client was allowed to possess. They got the definition instruction on what usable marijuana is. They heard extensive testimony on the dry marijuana versus wet marijuana and what qualifies as usable marijuana. So they got a lot. But then ultimately the judge reserved judgment for himself if, of course, only if the jury found that the state had met its burden, which it found across the board, except for on the question of because this is what this is about, allowable amount. And on those questions,
the judge makes the finding that immunity applies. Does the state get to argue to the jury that immunity does not apply?
I don't think the judge ever. Yes, the judge could, in certain cases, find that immunity applies. So let's say that a guy gets arrested, maybe he doesn't have his card on. He has an ounce of marijuana. He shows up in court, goes to trial, goes, here's my card. I did have it. I just didn't have it with me. I'm filing a motion to dismiss. The judge could grant that as long as the facts were not in dispute. As long as the defendant could stipulate to the
But if it's based on the amount and the facts are in dispute,
then it has to go to, yeah.
Judge, sorry to interrupt. Judge McMurray's having a little hard time hearing. Could you check to see if your lights are on? Should be green lights. No light on.
Sorry, yeah.
Ah, there we go.
Can he hear counsel?
Yeah, you can.
Okay.
I want to reserve some time. I do very much appreciate those questions, because they are really important about the best way to proceed with it and have some kind of uniformity moving forward. I agree with. I would only want to add though, that the burden shifting only happens if the state proves its case first beyond a reasonable doubt. There's no obligation on the defendant to prove anything unless the state has first proven that. Otherwise, we're in an innocent until guilty until proven innocent scenario, and that's certainly not what the Medical Marijuana Act contemplated. I'll reserve I think maybe I have 5 minutes.
Minute and 13.
He should get some extra time for us turning on the microphone, so if you'll give him an additional minute. Counsel, if you're ready.
Good morning. Am I prohibited from going to the podium, or
You're not prohibited.
I would be more comfortable at the
Then
podium?
go ahead.
Thank you. Good morning. May it please the court. My name is Michael Valenzuela. I'm here on behalf of the state. This case is appropriate for a remand. The trial court applied the correct law, and the law changed after the jury entered its verdicts. The change in the law did not affect the sufficiency of the evidence on the count on which Mr. Valentin was convicted, and so double jeopardy isn't implicated in this case. As for collateral estoppel, the issue to be resolved, immunity, that precise issue hasn't been resolved at any time prior in this case, so collateral estoppel doesn't apply either. For that reason, a remand is an appropriate, reasonable resolution to the unique circumstances of this case.
Okay, so let's say that Mr. Valentin enjoys no immunity. The jury's found beyond a reasonable doubt he did not possess marijuana or cannabis. Aren't we done?
No, not based on the general jury verdicts that were entered in this case. I think it's important to note that when you look at the cases that discuss why collateral estoppel is applied sparingly in criminal cases, it's a line of Arizona cases that eventually trace their roots back to a Supreme Court case. And that case recognizes that in a criminal case, the state doesn't have the ability to challenge a jury verdict that may be inconsistent with the weight of the evidence. The U.S. Supreme Court has recognized that juries can base their verdicts based on the evidence presented at trial, or it can be the result of a compromise or jury compassion. For that reason, the U.S. Supreme Court has cautioned against collateral estoppel in these cases because we don't know if the jury's findings on the facts actually line up identically with issues that may resolve in the future. And
Can you make sure that your button is pressed and there's a green light?
there is.
Okay.
Yes.
Speak into the microphone. The people in the back are having a hard time hearing
Oh,
you.
okay. Going back to the ability to line up the specific findings in the past with the specific findings in the future, I think that really does come into play here because although the jury found that he hadn't possessed marijuana or he hadn't possessed cannabis, and specifically, for this remand, what we're really concerned with is the items found in the backpack. The state doesn't want to go back and relitigate the things found at the Westcott house. This is about the items found in the backpack at the Schick Street house. And Mr. Valentin testified at trial that the items in the backpack were his. He took responsibility for those items. And those items included 10 to 11 ounces of leafy marijuana by his own admission. 5 to 10 ounces of that was dry and usable by his own admission under oath, as well as an amount of tincture and hash. And he couldn't recall how much that weighed when he was asked at trial. Now, he took that testimony, and in closing, he argues to the jury, hey, I did possess these things. I possessed the marijuana, but I didn't possess it in an amount over what I was permitted to possess. Although the jury wasn't specifically instructed on the immunity provisions of the AMA, as counsel recognized, stipulation came in and told the jury, Mr. Valentin under the AMA is allowed to possess 12.5 ounces of usable marijuana. And defense counsel in closing argued, he didn't go over that amount for the dried marijuana, so even though he possessed it, you have to find him not guilty. And then with the cannabis, Mr. Valentin kind of fell on the sword. And I'm talking about the cannabis found in the backpack. He argues to the jury, yeah, I possessed this cannabis, but it wasn't in an amount that shows that I intended to sell it. If anything, it's simple possession. So I think you can look at those arguments that were given to the jury and come to a reasonable conclusion that the jury could have both found that he possessed these items and still found him not guilty of those crimes as they were charged.
When we look at Fields, This is what it says directly. Should the defendant fail to establish immunity, and let's assume for your argument that he failed to establish immunity, the state, of course, must prove all elements of the charged offense beyond a reasonable doubt at trial. This went to the jury. The jury found beyond a reasonable doubt that Mr. Valentin did not possess marijuana or cannabis, which now we know is also marijuana after Jones too. I don't know why I keep doing that. What do you hope to gain?
Well, we don't hope to gain anything. It's Mr. Valentin appealed his conviction for the possession of the tools and chemicals for manufacturing cannabis, and I think he's correct. I think that the AMA and the broad language within the AMA's definition of medical use permits manufacture and possessing the items for manufacturing cannabis. All we want is the correct procedure to be applied in determining whether or not he had immunity. And under Jones, there is an important factual finding that has to be made to determine whether or not he has immunity. And based on the record we have right now,
why couldn't that record have been made at the time of trial? Certainly the court was discussing instructions in the context of, I'd like to make sure this works regardless of what the Supreme Court does with Jones. Why couldn't the state at that point have said, we need a separate interrogatory that even if they find him innocent of a crime for purposes of the equipment charge, we need a separate interrogatory that says we'd like a finding by a preponderance whether he has immunity?
well, let me respond on that in two ways. First, at the tail end of your question, you phrased it in terms of asking the jury if he has immunity. That's not a question for the jury. The jury resolves the factual disputes.
Okay, but
the judge
asking the
has
jury
make
to
the
decide an amount.
Sure. It's because it wouldn't have been relevant, and there was two open questions going into the Jones Supreme Court opinion about if it was reversed, how do we deal with cannabis? The state to the Court of Appeals had argued in Jones 1 that, do we weigh cannabis in terms of its simple weight, or do we weigh it in terms of some conversion rate? Because if we weigh it in terms of its simple weight, that could allow someone to possess much more marijuana than they could if they just had, 2.5 ounces of leafy marijuana. And so it was unresolved at that time whether or not a jury would even, let's assume that it would have been proper to speculate about Jones being overturned on appeal, which it wouldn't have been. I don't think we want to encourage trial courts to try their cases based on their anticipation of what may happen with another case that's pending review in the Arizona Supreme Court. But even if we did, we don't know whether or not the jury should have been instructed, okay, if you find that he possesses cannabis, you have to find how much he possessed based on the simple weight, or what the Supreme Court actually said, the amount of leafy marijuana that was used to make that cannabis. And so I think it would have been both irrelevant and it would have confused the jury if the state had tried to anticipate this and include it in what already became really confusing jury verdict forms.
Let's take as a given that there was maybe no reason to do it. If we were starting today, given Jones, are you suggesting that the procedure should be that the jurors should be instructed to determine the possession counts, and if they come back with and let's say, sorry to make offer a long hypothetical, but the same hypothetical I gave opposing counsel, if the jury comes back with, and they say he's guilty of possessing 1 ounce or one ounce of marijuana, do the jury then have to be instructed on the immunity defense? And we want you to tell us how much you think he possessed by a preponderance of the evidence.
In that hypothetical, would the state have charged him with more than 1 ounce of marijuana?
Yes, assume the state charged, thought it was an amount far exceeding the allowable amount. The jury comes back and says, we find that he possessed 1 ounce.
What do we do then?
Are you aware of any circumstances where we instruct the jury to make findings under different burdens of proof?
No, there's really not another circumstance that I can think of where the jury would have to do this in such a bifurcated proceeding, but
Does
the
that seem
AMA gives us
confusing?
what it gives us. And ultimately, I think what it would be is if we had a situation under your hypothetical where the state in its indictment had charged the defendant with 2 pounds of marijuana, they went to trial, a special verdict form was given to the jury to first determine how much marijuana he possessed. And the jury comes back and says, we find by a preponderance of the evidence that he possessed 1 ounce. I think at that point, the trial court dismisses any counts related, and that would be immunized under the AMA.
So
The
why
jury's
isn't-
made its finding on.
So why isn't that the same result here? Didn't the jury come back and said the amount is 0? Why? Let's say the jury had said 1. So you wouldn't be coming back if the jury had said 1. We wouldn't go back on the equipment charge if the jury had come back and said 1 ounce.
If we had special verdict forms in this case, and the jury had specifically marked, we find that Mr. Valentin possessed 0 ounces of marijuana, and we find that Mr. Valentin possessed 0 ounces of cannabis, we would not be asking for a remand. There would be specific findings on possession. Those would be controlling, and I think that the state wouldn't be able to then go back.
Why is a verdict that says not guilty of possession,
Well,
why doesn't that translate to possession of 0 amount of marijuana or cannabis?
I think it goes back to what I was saying about why we don't apply collateral estoppel in these types of cases, because we just don't know why the jury made that decision. We can guess about why they made that decision.
But you're telling me you wouldn't if the jury had come back and said 1. You wouldn't seek a remand if the jury had come back and said he was guilty of possession of 1 ounce of marijuana.
Well, in that instance, there would be a specific jury finding on what he possessed.
And you're saying a not guilty verdict is not a specific.
It's not a specific finding. They could have found that he possessed 0, but there is an equal chance they could have found that he did possess some amount, and it just didn't go over the allowable amount. I think that's inherent in the argument that he presented to the jury.
Can't you make the same argument with if the jury came back and wrote in 1 ounce? Well, the jury could have thought there was more, but they only want to convict him of. I'm not seeing the distinction between a 1 ounce verdict and a 0 verdict.
I think the distinction is that an acquittal doesn't necessarily mean a 0 verdict, given that the AMA immunities and the allowable amounts in this were argued to the jury in this case. There was an acquittal, but that acquittal could have been based on a finding that he had 0 all the way up to 12.4 or 12.249999999 ounces of marijuana, as long as he didn't go over that.
But if they came back with 1
limit.
ounce, I mean, you could say, you're saying the state wouldn't come back and challenge the 1 ounce number.
Well, in this particular case where he's allowed to possess 12.5 ounces of marijuana.
And if they said 1 ounce, you wouldn't challenge that, even though they could have. He testified that he was in possession of more than 1 ounce. It seems to me the same logic should apply, and I'm not following why. I'm still not following why 1 is different than 0.
I think it's just different because you're comparing a specific jury finding where they've actually made a notated decision on how much he possesses.
They were told to do that. If you find him guilty, then you're supposed to come up with an amount. So it seems to me that finding seems to suggest the amount is 0.
I just respectfully disagree, Judge. I think that the verdict in terms of an acquittal it's open-ended. They could have found that he possessed any amount up to 12.5 ounces. And so for that reason, it's just not, I don't think that it would be appropriate in this case to automatically assume that to 0. And, this goes back to the issues of why the Supreme Court has cautioned against using, what this goes to is it's a collateral estoppel issue. It does this specific factual finding on the amount that he possessed or didn't possess. Does it go back to, does it preclude a rehearing on what he may or may not possess? And I also want to add that it's also inappropriate because we have that shifting burden in this case. We have a lower evidentiary burden that would be applied in determining whether he had immunity, and it's on a different party. And the section of the restatement on judgments that I referred to in my notice of supplemental authority recognizes that these issues of collateral estoppel really shouldn't be applied when that type of thing is happening.
But again, and I hate to just belabor the point, maybe you've already made it, but if we're in just a complete hypothetical world, I'm just curious if the state is proposing that we do that when they come up with a number, they come up with a number 1, because it's a different burden of proof, the state in theory has a right to another jury finding, and you're not suggesting if there is a number at all, you're not suggesting that the state wants to come in and have the jury make a separate finding under a different burden of proof?
Once they find, I'm assuming you're talking about once they find an amount
if they
in litigating the immunity issue.
Right. But if they found 1, you're saying it's a different burden of proof. So why shouldn't that apply and let the state come in and ask them to make a different finding by a preponderance?
I think it's just because that's the way that if we're accepting what the Fields decision says, that's the way that the immunity provision for these AMA cases work in criminal cases. The jury resolves these facts by a preponderance of the evidence, and then the court makes its ruling. Once a finding has been made on that weight by the jury.
But the only thing they found was that the state didn't prove a crime beyond a reasonable doubt. The jury didn't make a finding by a preponderance. And I'm not suggesting it seems like a confusing procedure to ask the jury to apply 2 different burdens of proof, and I can't think of any other instance where we do that, but I'm trying to understand what the correct process would be if you think that's a completely different inquiry than what the jury determined in their verdict.
Well, let me take your question and kind of separate it from the facts of this case a little bit, because this is such a unique case with such unique facts and the way that the jury verdict forms
if you
were
could just
created.
think
But
of it in terms of all we're charging is marijuana possession.
Yeah.
And he has a medical marijuana card. The state thinks he has more than the allowable amount. The jury comes back and says, we think he has 1 ounce. The state thinks he has more than that, and he doesn't have immunity unless he's under the allowable amount. What's the procedure you're proposing for that count?
Well, let me start at the beginning, if I may. If the state brings the charge and it's alleging 2 pounds, and the defendant comes back and says, well, I have a medical marijuana card and I didn't possess 2 pounds, I only possessed the allowable amount. The court would then have to determine whether or not there are material factual disputes. And in this case, the dispute between 2.5 ounces and 2 pounds would be material. The case would then go to a jury, and the jury would be asked to make a finding on how much he possessed. I think that once the jury makes that finding, the judge has to make a ruling on immunity. If the jury's factual finding is an amount less than the allowable amount, then at that point the trial court applies the immunity. Of course, the problem with this whole process is that to a large part it defeats the benefit of an immunity. What you want in an immunity is to be able to come in and present your card and say at the get-go, I shouldn't have to go through this whole burdensome process of a prosecution because I have an immunity. But accepting Fields the way that it's written, this is the process that we have, unless the court comes to some other decision that because a lower standard of proof, a preponderance of the evidence standard applies on this immunity question, that the question can be resolved without a jury. Now, I'm not suggesting that. I didn't argue that in my briefing. It wasn't argued below in the trial court. It's not an issue that's been preserved in this case. But part of the, I think, problem in applying this in this case is the way that Fields is written and the way that it's resolved. We're just trying to find a way to do these things in a way consistent with Fields.
And if we set Fields aside, what do you think the procedure should be?
If we set Fields aside, I think that because there's
Wide open playing field.
I'm sorry?
Wide open playing field. You're arrested, it's alleged 2 pounds, you say you only have less than 2.5 ounces. How do we deal with this immunity thing? The state's going to prosecute you. You have immunity from prosecution. What do we do? It
could be a matter of a pretrial evidentiary hearing that could be decided by the judge.
When we talk about a pretrial evidentiary hearing, the state seems to be filing motions in limine to address the fact that the defendant can't use the immunity as a defense. So is that the stage in the game we should be dealing with this?
I think it would be most appropriate to deal with it at the beginning of the case once disclosure has been undertaken. I'm not quite sure about. I don't think it would be appropriate if the state's saying that it can't be used as a defense in the case. That terminology is a little bit confusing because it's not actually a defense. It's an immunity. It's a bar to prosecution. I see that my time's almost up. Do you have any further questions?
I do, and I'll give you extra time. You okay with that?
Sure.
Okay. I understand what you're saying. Immunity should take this out of the realm of prosecution. And what I am struggling with is a process developed in Fields which applied to a grand jury case, not the actual trial. So I have a problem waiting till the end of a prosecution to say, oh, you had immunity, you're all good. That's a whole lot of due process, jeopardy, all of these things that attach when you're charged with a crime that you should have immunity to. So if a clean slate, you think it should be a pretrial motion to be cited by a judge?
I do. I believe it could be akin to the kind of procedure we have for motions to suppress, the kind of procedures that we have for Rule 404B hearings, where evidence is presented to the judge and the judge can make a determination on whether the facts merit an application of immunity. Now, let's imagine that type of situation.
Aren't evidentiary rulings a little bit different, though, than a defense? Seems to me if I were the defendant, I wouldn't mind having a pretrial hearing, but I would also want the opportunity to present it to the jury.
And I think you could. I don't think that if the judge made a finding that you didn't have immunity, you would be precluded from still arguing your case to the jury. If you argue to the judge, no, I didn't possess these things, and the judge finds that you haven't proven beyond a preponderance that you didn't possess them, that doesn't preclude you from then arguing that same thing to the jury, and from the jury finding based on that argument that the state hasn't proven its crime beyond a reasonable doubt.
And in that case, we would have to have this scenario where the jury is instructed to find something beyond a reasonable doubt and then to find the same basic fact by a preponderance.
No, if the judge, if we have a process that's separated from Fields and the judge is making the immunity decision at the outset, then I think
But I'm saying the judge said, I'm not finding immunity. And if we're saying that the defendant still has the right to present that to the jury, then we still have this problem of, well, you've been convicted of this amount beyond a reasonable doubt, and now to establish immunity, we have to have the jury address it in the context of a different burden of proof, which seems very confusing.
I suppose I'm a little bit confused by your question, because in the hypothetical that we were discussing where the immunity issue is decided before trial by a judge, I don't envision a reason that the jury would have to redetermine immunity.
But so you're saying the defendant would not have the right to argue immunity to the jury under that scenario?
No, I don't believe he'd be able to argue immunity, but he could still argue the same factual disputes and he could argue that those same factual disputes undermine the state's case and show that the state hasn't proven their case beyond a reasonable doubt. Thank you, Your Honors.
Can you add a minute 30?
To the 3
He
now.
already has 3. If you need more than 4 minutes.
Yeah.
Okay, great. Judge Campbell, I want to, you're asking me a straightforward question. What do I think? And I realized I was answering that constrained by the Fields decision that we're kind of, that we're accepting as the way things have to be. But if on a clean slate, putting Fields aside for the moment, how do I think it should work? I think that we should have the state required to prove its case beyond a reasonable doubt where you have a defendant asserting a medical marijuana defense. The state should have to prove the possession beyond a reasonable doubt and the amount possessed beyond a reasonable doubt. And we shouldn't get into any of this burden shifting. The burden should be on the state the whole time.
But that necessarily requires a defendant to wait until a jury verdict to enjoy the protections that AMA was adopted for. That's what I'm struggling with. If the intent of AMA was to allow people to possess marijuana for medical purposes, And that only means you're allowed to possess it and be prosecuted, but at the end of the prosecution, you can assert your immunity. That undermines everything that was meant to be taking place in AMA, does it not?
Yeah, I agree, but the problem there, Judge, is that most defendants, I think, given a choice between a judge deciding whether they qualify for immunity or a jury, would prefer to have a jury for obvious reasons. I mean, there's a reason why we have a jury process. It ensures fairness, a jury of his peers to decide that question. So
I get that, but shouldn't there be some sort of mechanism at the very onset for a defendant who, I don't know what they possess, something far less than 2.5 ounces of marijuana, can say, I have my card, I guess you could do a motion to dismiss, but you're
Yeah.
already being prosecuted.
That's right, motion to dismiss. Now, what happens, though, the question is, well, what if the defendant loses that motion to dismiss? Does that mean that they can still preserve and present that defense at a jury? Because right now, the courts say, well, no, if you file a motion to dismiss, I say, no, you're outside. Well, not necessarily. But if the state files a motion in limine and says they're outside of the Medical Marijuana Act, and the court grants that, which happens all the time, then that's it. So the judge doesn't think that the person's entitled to immunity, and the jury never gets to consider that. So that's my concern about having it all up front on the judge, is I'm fine with that as long as that doesn't then preclude the jury from also being able to consider that same defense. I also just wanted to point out one thing, because the state has said in its briefs and here that somehow the Supreme Court in Jones announced a new standard about you calculate the allowable amount by how much flour it took to make the cannabis in question. I did attach as Appendix A to my reply brief, what was the amicus brief in the Jones case by the former director of the Department of Health Services. Paragraph 61 says, for years, all along, that was the standard. The only time that changed was when Jones, the Court of Appeals decision in Jones. So this was no new standard. This wasn't something that caught the state by surprise, that they couldn't have anticipated. They made a choice to gamble that Jones wouldn't be overturned, failed to make a record, and now want to relitigate the very same issues for
But
which...
the law was decided with the first Jones case, that everybody's bound by the first Jones decision.
But of course, listen, they know that it's on appeal. They knew it was pending appeal at the Supreme Court. They made a strategy decision. They certainly could have asked for findings and that sort of thing. I was definitely bringing it up constantly throughout the trial. They decided they wanted to rely that Jones would be upheld and didn't think it was necessary to make a record just in case there was a different ruling. And they're stuck with the consequences of that. They don't just now get to relitigate those very same issues for which Mr. Valentin for 13 days went to trial and was found not guilty of. To force him to have to go through that again is precisely what the the double jeopardy clause was meant to preclude. So I would ask that the court, not just that the court completely overturn the conviction in this case. All of the factual issues have been already decided. There's no need to go back and remand. We know already that the jury decided he was within his allowable amount of dried flour and that he was in possession of no cannabis. So there's no need to go back and try to relitigate how much cannabis he had when we already have a jury verdict beyond a reasonable doubt that he had none. So thank you very much. I appreciate your time and your interest in this issue. Thank you.
Counsel, we appreciate your arguments. This is a novel issue, and it really has been engaging. So we're going to take this matter under advisement. We'll issue a written ruling in due course. We are adjourned.